You will receive a subpoena. A subpoena is an official request to come to court. It is an order from a judge that says you must come to court on the date and time listed on the subpoena. Don't be scared. You probably have done nothing wrong. You may have seen or experienced something that is relevant to a criminal case. You are a witness. You must go to court on time and on the date shown on the subpoena. This video was produced to help you become familiar with the policies and procedures of the court as they pertain to you, the witness. You may have an interpreter assigned to you from the court. He or she will translate the questions to you and then translate your answers back to the court. As a witness, you always should arrive on time. You may be asked to remain outside the courtroom. You may be met by your victim advocate, the district attorney, and/or an inspector from the DA's office. This is the inside of the courtroom. Here is where you will be asked to give your testimony as a witness. There are certain rules and procedures in the courtroom that you as a witness should know. The judge sits at the bench. Here is where the jury sits. The uniformed officer is called the bailiff. The bailiff is in charge of security in the courtroom. And the district attorney, along with the defense attorney, are seated here in front of the judge. This is the court reporter. She or he writes down everything said in the court. And this is the court clerk. The number one rule is to tell the truth. You must tell the truth about everything. What you saw, if you don't understand the questions, or if you need to use the bathroom.
Anna, we're ready for you.
Always tell the truth, no matter how difficult it may seem.
Please raise your right hand.
Favor de levantarse la mano derecha.
Do you solemnly state,
Usted declara solemnemente,
under penalty of perjury,
bajo penal perjurio,
that the testimony you are about to give shall be the truth,
que el testimonio que usted está para dar será la verdad,
the whole truth, and nothing but the truth?
toda la verdad y nada más que la verdad?
Sí.
Yes.
If you don't know the answer to a question, or if you truly don't remember, just say that you don't know or that you're unable to recall. Your accurate testimony is very important, and people's lives may be affected as a result of what you say. The best course of action is always tell the truth. When you are asked a question, listen to it completely. If you do not understand the question, say, "I do not understand the question," and then wait for the question to be repeated or rephrased. You may take a moment to answer the question accurately and truthfully as you can. If you need to take a break, it's all right. Just ask the judge or the district attorney. Always answer out loud. The court reporter is writing down everything that is said in the courtroom, so head movements, hand gestures, or interjections are unclear. You need to answer with words. For example, do not say, "uh-huh," or nod your head. Say yes out loud. You should always be polite and respectful to all parties, even to those on the opposing side.
You were attending the party in question?
¿Asistió a la fiesta de Juanita?
No fue el 22 de agosto,
No,
fue el
no, it wasn't the
27.
22nd, it was the 27th.
Don't worry, even if you think the questions from the defense attorney are making you look bad. The defense will often ask you lots of questions, which the answer is either yes or no. You might feel that lots of important information is left out of those answers, leaving things unclear. The district attorney will have a chance to ask you some more questions after the cross-examination and will go over everything that may be unclear. If you have prepared for court with the district attorney and/or victim advocate, don't be afraid to answer questions about that from the defense attorney. You may be asked how many meetings you had or what you've talked about. Again, as always, just answer honestly. When you are a witness, you may be asked questions that are upsetting or that may cause you embarrassment. Remember that you're safe in the courtroom, and it's all right to feel upset or embarrassed. If you're answering a question and one of the attorneys says objection, you stop answering. There are sometimes legal reasons why certain evidence can or can't be included in court. The judge and attorneys may talk a little about the objection. You just need to wait until the judge tells you what to do, either to continue answering or to wait for the next question. Don't worry, it doesn't mean that you've done anything wrong. Make sure that you and the interpreter understand each other. If not, you need to inform the court or the district attorney immediately. When you're being asked a question through an interpreter, wait for the whole question to be translated before you begin to answer. Do not answer a question without a translation. Allow the interpreter time to translate what you are saying, especially if your answer is long. Again, if you do not understand something, say, "I do not understand." It may be that you and the interpreter mostly understand each other, but there may be one word or phrase that you don't fully understand or that you think they have not understood from you. If this is the case, tell the court or the district attorney as soon as you realize there's an issue with the interpretation. In conclusion, remember, if you don't understand a question, say so. Always be polite. Speak up loudly and clearly when answering a question. Keep checking that you and your interpreter understand each other, and always tell the truth.